Pode começar, Paula.
Olá a todos e todas que estão nos assistindo na Conferência Internacional sobre Acesso à Justiça e Clínicas Jurídicas. Chegamos ao nosso último dia, nosso último painel, um painel muito especial, só de mulheres, para falar sobre direitos humanos e o papel das clínicas jurídicas. Tenho o prazer de receber a professora Caroline Lopez. Professor Caroline Lopez is a professor of law and director of Human Rights Clinic at the University of Miami School of Law. She also serves as adjunct senior fellow at the Council of Foreign Relations and fellowship for her Courage in Policing project. The Human Rights Clinic, under Professor Lopez' supervision leadership, is 3,000 Florida-based community organizations are joint recipients of a grant from Time's Up Legal Defense Fund to start Voces Unidas in project to support low-wage immigrant women works who have experienced workplace sexual misconduct or related retaliation. So we're going to have a presentation with 4 legal clinic professors that work both with violence, domestic violence and gender, and also immigrant and immigration issues. So we're going to start with Professor Carrie Lopez' presentation. Professor Lopez, it's a pleasure to see you for the first time, to meet you and to learn from you. Thank you so much for being here. The floor is yours.
Thank you very much, Professor Montero Danese, and also Professor Baker from Pepperdine. It's such a wonderful pleasure to be with this great group of, quite frankly, old friends and new friends as well. And I'm looking forward to the conversation. I do want to say I will need to leave the conversation a little bit early due to childcare responsibilities, which is our lives that we balance, and is an important part of actually talking about our work as clinicians and as professionals and the many hats that we wear, because that's an important part of our role, is to communicate that balancing act. I also need to just mention that I recently took on a role in the White House as a special advisor to the Gender Policy Council. And I need to just emphasize that I am not speaking on behalf of the White House right now or in my official capacity with the federal government, but I'm speaking with my professor hat on and about work that I've done prior to taking on the White House role. So I'm excited to speak about work that I have done and that both Professor Drew and Professor Keyes have been a very important part of this work and kind of the extension of this work. The idea is kind of captured by the term bringing human rights home. The idea that here in the United States, we have historically had a kind of notion of human rights as something that happens somewhere else in the world, problems that happen elsewhere, that we think of ourselves as exceptional in some ways and practice US exceptionalism. And so I'm part of a network of US lawyers and advocates who have sought to dismantle that that notion, and Professor Drew and Professor Keyes are a very important part of that network and that work as well. And so the story that I'm going to tell you about my clinic's work on a case that really changed my life is a story not only about how my clinic students and I got involved in framing domestic violence as a human rights violation in the United States, but it's also a story about bringing human rights home to the United States it's like a double entendre, right? It's bringing human rights home, making sure that we are holding our own country to international human rights standards, and bringing human rights home, making sure we're looking at domestic violence, the violence that happens inside the home, as a human rights violation, as a very fundamental human rights violation that is actually probably the most widespread human rights violation in the world. And sometimes when something is so widespread, it's invisible before our eyes. And so that's what I want to talk about today. So if you could please start the PowerPoint, Jeff. I have some slides that I want to show you, and I'll go through them, and hopefully this will work. So this is great. So this is a photo of Jessica Lanahan, my client and my student's client. And if you could go to the next slide, I want to tell you about her story. So just briefly, when we think about intimate partner violence in the Americas, I want to frame Jessica's story in terms of this story. Of course, I'm sure many of you in Brazil have worked on domestic violence issues. You have some really important and inspiring laws and policies, of course, like the Maria da Penha law, that have heavily influenced my way of thinking about state responsiveness to domestic violence. And so if you could go to the next slide, please. These set of slides are just intended to show really the devastating impact of domestic violence, or also known as intimate partner violence in the Americas. 1 in 3 partnered women in their middle age period young to middle age, have experienced physical and or sexual violence by a partner. This is a huge epidemic. It is the invisible pandemic that no one thinks about as a pandemic, but has only actually been exacerbated during times of COVID. Next slide, please. And this is just a breakdown it's fine. This is just a breakdown. It's from a PAHO report, the Pan American Health Organization, for anybody interested in seeing the rates of intimate partner violence in the Americas. They are quite staggering, and every country is here. You can go ahead. Thank you. So let's talk about the United States and our statistics and how these statistics framed our case. We have statistics that are similar to many countries. Domestic violence is the leading cause of injury to U.S. women. Each year, 1.3 million women are physically assaulted by an intimate partner. 1 in 4 U.S. women are abused by their partners, and 50% of homeless women and children are fleeing domestic violence. That number is actually probably much higher. This is just the tip of the iceberg. Next slide, please. And so the question that confronted me as a young lawyer, I was working at the American Civil Liberties Union, which is a major organization, a civil rights organization. The question was, what's the responsibility of the state to protect from private acts of violence? And if you go to the next slide, and I'll tell you about how this question came up in a moment with the case, but I want to just kind of emphasize the conflict, right? The place where U.S. law and international law really conflict and are hard to reconcile. In the United States, we have a constitutional law framework that many people call a negative rights framework that basically says that there's no government duty to protect individuals from private violence. Whereas there are positive obligations in the international human rights context, where the state, if there is notice about a real and immediate risk to an identified individual, has a duty to protect that person, to prevent the harm if they can. So if you could go to the next slide. So I want to talk about the case of Jessica Lanahan and the role that our clinic played in this case. In 1999, Jessica, she is a woman of Latina and indigenous descent living in Colorado, and she obtained a restraining order from a court that prohibited her husband from having contact with her and her 3 daughters. He violated the order, kidnapped the children, drove around with them for nearly 10 hours. She made repeated calls to the police. The police essentially ignored her calls for help, did all these other things like go to a 2-hour-long dinner and respond to missing dogs. And tragically, and I'm sorry, this is a trigger warning. It's a difficult story. He showed up at the police station at 3 o'clock in the morning. The police opened fire on him, and he shot at the police station. They shot and killed him and found the bodies of the girls dead inside his truck. And there is a YouTube video that I can share after this that kind of where Jessica tells this horrible story in her own right. Next slide. So this was the language of Colorado law. In the US, much like in Brazil, we have a federalist system where we have federal law and we have state law and we have local law. But in the context of domestic violence and the enforcement of restraining orders, that is considered a state law issue. And so under Colorado law, we have something that most states in the United States have, which is called a mandatory arrest law. These laws were designed to remove discretion from police because police historically turned a blind eye and a deaf ear to domestic violence survivors. And so this law was meant to remove that discretion. A police officer shall enforce a restraining order, shall arrest if they believe that a person has violated a restraining order. This text seemed pretty clear. Next slide, please. But the chief of police of the Castle Rock Police Department insisted that there was no major cause for concern, right? He says, what safer place could children be than with one of their parents, the mother or the father, really underscoring the gender stereotypes and the lack of understanding of family violence that the chief articulated, and that trickled down, of course, to his officer's response to the violence. Next slide. This is a very sad photo of the truck the morning after the shootout. You see the truck was riddled with bullets. And look at this headline: man dies in shootout, daughters found dead. Family was troubled, friends say. There is nothing in here about state responsibility. There's nothing in here about the role of the state to protect those 3 little girls and Jessica. There's nothing in here that removes, that zooms out. And instead, there's this focus on troubled families, right? Again, we come back to this question of bringing human rights home. Next slide. So Jessica sued the Castle Rock Police Department in a civil rights action, and she made a constitutional claim that her property rights under the Constitution, her 14th Amendment due process rights, were violated when the police failed to enforce the order. If you remember that slide in the beginning where I showed the arrows that showed the conflict of international and domestic law, she had a very narrow legal argument to make. Unfortunately, Justice Scalia, writing for the majority in 2005, found in favor of the Castle Rock Police Department, found that Jessica Lanahan had no constitutional right to have her restraining order enforced by the police. And this is the text of the decision. That, remember that language of shall, that the police shall arrest? Well, he says that wasn't mandatory. And I know that many of you are not native English speakers, but I know that even you are saying to yourselves, that doesn't make any sense. And you are right, it doesn't make any sense, even if you are a native English speaker. So this was a devastating decision. And I want to talk for a moment about what I call survivor-led advocacy, because it was at this moment that I was like a baby lawyer at the American Civil Liberties Union in their women's rights project. And I was responsible for doing the amicus briefs to the Supreme Court. And you may know that amicus briefs are friend of the court briefs, and they're briefs that communities and organizations and individuals and experts submit to a court to say, here's some different perspectives on the particular issue before the court, and we want you to keep this in mind as you make a decision. And so I helped to coordinate 9 amicus briefs from about 150 individuals and organizations when I was at the ACLU. And but when the Supreme Court decision came down, Jessica said, or rather the lawyers, we all kind of threw our hands up and we were like, well, it's the Supreme Court. It's the end of the line. There's nothing we can do. And it was Jessica and her mother that insisted there must be something you can do. There must be some way to hold the Supreme Court accountable. And this is a very humbling moment for me because at the time I thought, oh, you know, she's just kind of insisting on something that's not really possible. But it was really, she forced me to step back from myself, to take my lawyer's hat off and think kind of creatively about how we could reclaim her dignity and rights through quasi-legal or legal mechanisms. And so the next slide, please. So we came up with this idea, the legal team came up with this idea of the Inter-American Commission on Human Rights. And as I said, many of you probably know the Inter-American human rights system probably much better than most of my law students, because it has a much different significance in Brazil than it does in the United States, where it's relatively unknown to most lawyers and even most law students. Next slide, please. So as you may know, the Inter-American human rights system is made up of 7 independent experts at the Inter-American Commission on Human Rights. And then it also has an Inter-American Court of Human Rights. It's based in San Jose, Costa Rica. And this, and as you see, everybody from Mexico south, for the most part, is a member, has ratified the American Convention, as well as many other international human rights instruments. Unfortunately, the United States and Canada have not acceded to the court's jurisdiction, but we do have the commission. And so that's the beginning of the Inter-American story. So go ahead to the next slide, please. I think I might just skip ahead a few slides. One more. Thanks. Okay, perfect. So the American Declaration on the Rights and Duties of Man does articulate several rights that we submitted. We submitted a petition claiming that Jessica's human rights were violated. We had exhausted domestic remedies. We had gone to the highest court in the land, which was the US Supreme Court. And so we were able to take the case then against the United States to the Inter-American Commission. And they found in her favor. They issued a beautiful decision finding that the US government failed to exercise due diligence, a concept that they rooted largely in the Maria da Penha case from Brazil. And that was referenced in many places throughout this decision. Failing to enforce Jessica's restraining order, failing to protect the daughters, failing on a systemic level to protect. And so if you go to the next slide. Thank you. Okay, so this is a photo, and I actually don't have a photo here, but there's another one of these photos that's very long, and it has a photo of all the clinic students who were involved in this case. So after I left the ACLU, beginning in 2006, clinic students worked on every aspect of this case. And so I want to just kind of emphasize how important it was to build the case and how impactful it was for our client to interact with clinic students at every stage. So here in the middle, you see Jessica Lanahan and her son Jesse and her daughter-in-law Nikita and her mother Tina, along with the legal team. And we really centered their experiences throughout the work. So we had clinic students who took a declaration from Jessica's mother, Tina, and from her son, Jesse, and submitted their declarations to the Inter-American Commission about what their experience was. Likewise, clinic students developed a declaration from Jessica and helped her to prepare her testimony, where we had, and if you go to the next slide, is a photo of the merits hearing before the Inter-American Commission on Human Rights. And you see behind the petitioners are stacked with clinic students and advocates who attended this hearing to show solidarity and support for Jessica. So it was a very powerful moment. So if you could skip to the next slide. This next slide just kind of articulates the 4 different areas that the commission found had violated Jessica's rights. But I would just say that, you know, the clinic was really involved in thinking about these 4 different sets of rights and a few others. And the students did intense research on each of these rights and wrote a merits brief that that talked about the foundations of these rights within the inter-American human rights system, but also looking to other human rights systems like the United Nations, the European human rights system, the African human rights system, as well as domestic law in various places. And the students also helped to coordinate amicus briefs that went to the Inter-American Commission in support of Justica, which showed kind of a hemispheric attention to this case in a very powerful way. So if you go to the next slide, actually, I'll skip ahead. These next few slides, and I'm happy to share these slides afterwards. They just contain some nice quotes from the Inter-American Commission. Okay, so I just want to talk, I probably need to end in a moment. So I want to talk just for very briefly about what we did with the case. And because again, like each time in a case, and this is something we talk about a lot in the clinic and we process in our supervision meetings with the students, and then also when we have project and case rounds in the classroom with the larger student teams, is like, what does it all mean, right? Like each time you have a victory, you have to celebrate your moments because it's such a powerful moment, but you also always have to be thinking about kind of the next 5 steps. And so our students really talked about what bringing home this incredible decision meant, because what does it matter if the majority of Americans don't even know that the Inter-American Commission exists? The State Department and the US government don't acknowledge that their decisions are binding. So how do we make it actually real at home? And so the students and along with kind of the great coalition that we had built, which really included Professor Drew in so many important ways. We came up with kind of 2 tracks, and I think Professor Drew will talk about the second one a little bit. The first one was kind of thinking about the federal government and what the federal government could do, and the second track was about what local governments could do. And so I just want to talk for a moment about the first track, the federal track. So you see where this arrow is about addressing stereotypes and discrimination. These were the recommendations of the commission. And we thought, how can the federal government address stereotypes and discrimination regarding domestic violence survivors? And so go ahead to the next slide. And then you can skip ahead again. I'll keep talking and then hopefully it'll catch up. Okay, great, one more. So, oh, actually just back one. The Department of Justice, right, the same year as Jessica's case, we began meeting with the US Department of Justice and saying, and the Department of Justice didn't even really know that much about like this case or, you know, anything about kind of the impact of the case. And we kept just, we had to connect the dots for the government. And that was really important. And the students were a part of all of this, figuring out how to communicate to the federal government these human rights principles and what their domestic translation was. So there's a real translation mechanism that the clinic provided. And so the US Department of Justice initiated these gender bias in policing investigations into specific police departments. And if you go ahead to the next slide, they also issued guidance on gender bias in policing. And this guidance went to all 18,000 police departments across the country. Next slide. And there are 8 principles in this guidance that really kind of address gender bias in policing. And so we found that this was a way that, you know, this could trickle down to the local level. And I'm go to the next slide, and then I'm going to wrap up. This is the local track that I think Professor Drew will talk more about. The local domestic violence human rights resolutions track, where really Professor Drew and Professor Lee Goodmark, who are both fabulous clinicians, came up with this idea to take this international human rights decision and create local resolutions in cities and counties across the country that declared that freedom from domestic violence was a fundamental human right. And so if you go to the next slide, that's a list of some of the municipalities that have these. And just to finish up, I'll end on the next slide, which is that My students also really insisted that this was more than kind of a legal or legislative or municipal struggle. We had to trickle into popular culture, and so our students worked very closely with two documentary filmmakers who made this film called Home Truth. I recommend it to you. You can get it online, and it's a film about Jessica's struggle for justice and her life and how hard her life was and continues to be. It's not a happy ending. You know, it shows her continued struggle. I just actually saw her 2 weeks ago. We went on a retreat together, and we went camping and had an opportunity to just kind of do some reflection on you know, her entry from kind of this very public, visible space, legal space, to a documentary filmmaking space, as well as Broadway. So there was a hit on Broadway, which became an Amazon show, which you can see on Amazon. And it's called What the Constitution Means to Me. And it's an amazing show. It's a one-woman show all about basically how messed up our US Constitution is, and how, in particular, it excludes, it excludes so many people, but how women are fundamentally excluded from the Constitution and women's issues and the intersectionality of people's experiences. And so you'll hear Professor Keyes talking about her incredible work with immigrants' rights. And so the idea of kind of like immigrants and people of color and indigenous peoples and women and LGBTQ individuals being kind of excluded from our Constitution. And so the question of kind of who the Constitution is written for. So it's been kind of a beautiful journey with Jessica to go in all these different venues and think about the ways in which her case has made an impact on people in so many different fields. And she's truly heartened whenever she meets people from other countries, or when she knows that her case is being studied abroad. And so I told her that I would be here representing her today, and she's very grateful for your interest in her case and your support, and really many Brazilians' support of her case. It's been really phenomenal. So I will end there, and I'm looking forward to staying on for as long as I can. Thank you.
Thank you so much, Professor Lopez, for your presentation. I didn't mention before, but I knew the case of Jessica Lanahan when I worked for the Inter-American Commission in 2015. It's not a case in Brazil that we really study. We should. And then when I saw this case, I decided, I have to study more about it. So we have Maria da Penha here, and has a huge impact. But Jessica Lanahan has a huge impact as well. And I believe that the way it was built, and that was difficult, because the United States do not recognize really the Inter-American Commission is not part of the Inter-American Court. So it is a leading case for domestic violence in the United States, because what was built after the case that was analyzed by the Inter-American Commission. And I really love the Inter-American system. I'm a professor of the Inter-American system, and seeing this kind of work is inspiring for us in all the Americas. So thank you so much for your presentation. I will pass the word to Professor Margaret Drill. She's Associate Professor of the University of Massachusetts, Boston. And she teaches human rights, domestic violence, professional responsibility, and practice. Her field of research is gender violence, trauma and healing, and feminist jurisprudence and ethics. Professor Margaret, it's a pleasure to meet you, even though virtually. You have the floor. Thank you so much.
Thank you so much, Professor, and thank you for this kind invitation. And thanks to Professor Baker as well. I cannot overstate the role that Professor Bettinger-Lopez has played in influencing how domestic violence advocates approach their cases now through the human rights lens. She has been an outstanding leader in this field, and I just want to acknowledge the courage that Professor Bettinger-Lopez showed, along with her brilliant representation of Ms. Lanahan, and also the courage of Ms. Lanahan herself to her willingness to proceed through these various legal systems in seeking some acknowledgement around the harm that was suffered by the girls and by the entire family following their deaths. So what my clinic is named the Human Rights at Home Clinic. And the origins of that really come from doing this work on the Lanahan case and doing follow-up work subsequently. Carrie has adequately and very well explained the problems that the barriers that Ms. Lanahan faced in pursuing her actions through the U.S. legal system. We simply do not appreciate harm itself as a cause of action, particularly when there is state involvement in creating that harm. And in this case, it couldn't be more clear that the inactions of the police department were inexcusable, given the circumstances of what happened to the children, the failure to enforce the restraining order, and the lack of other emergencies for the police to tend to. When Professor Bettinger-Lopez described the court's reliance upon so-called property rights, and finding that Ms. Lanahan had no substantive interest in police enforcement of the restraining order, she's recognizing a fundamental flaw in the U.S. system. And I often think how offensive it is to base this ruling against Jessica Lanahan on property when a significant part of her heritage is indigenous in the United States, and whose property up until this day is taken away from the tribes and from individual Native Americans. So this was clearly an interest that developed out of the concepts of capitalism, and has become my focus of scholarship in tracing the histories of property interest and how the reliance upon property interest is detrimental to all of the people who have historically been marginalized in U.S. culture. So what happens in the U.S., as Professor Bettinger-Lopez referenced, is that we take the facts of a case and we try to see whether or not they fit any of the existing legal theories. So since the facts of Jessica's case did not fit with the Supreme Court's view of what a property interest is, she was denied relief. When you switch to the human rights perspective, it starts with the harm and whether or not that harm, the state had a role in causing that harm or exasperating that harm. And clearly in this case, the Colorado police did have a significant role in causing the harm and in providing no relief and no enforcement to Ms. Lanahan. So this is a case where, as any of you know who have discussed this, everyone is shocked, right, that you tell this to, particularly non-lawyers. Just can't believe that this mother found no relief in the U.S. court system. And so it was brilliant to take this case to the Inter-American Commission on Human Rights, and provides a profound difference in approach, but also in the humanity of the decision. So these two cases, the U.S. Supreme Court case, as well as the Inter-American Commission opinion, is the foundation of what my students study in the Human Rights at Home Clinic. And of course, as Professor Bettinger-Lopez mentioned, the arrogance of the US had been to look at human rights violations only in other countries, whereas we have more than sufficient human rights violations in the United States that need attention. Excuse me. So the students, like others who read these opinions, are appalled that there was no way to bring relief to Jessica Lanahan. And so it reframes how we look at how we are going to represent our clients who are survivors of domestic violence. It brings a more holistic view to it. The students represent clients who are survivors of domestic violence, primarily in the family court and in the appeals court in my clinic. The family courts, as with family courts all over the world, are becoming less receptive to hearing the claims of abused women. The latest and biggest challenge to abused mothers is the claims of parental alienation, which I know Brazil that is a growing movement there as well. And what that does is it turns the mother's claims of the father, typically the father, or the partner being abusive, it flips the narrative from the abusive partner's behavior to the mother raising this abuse just to alienate the children from the father. And it's been wildly successful. And as far as I know, none of the state Supreme Courts have been willing to take this issue on, or their highest courts have not been willing to address this. Whereas other countries have taken it on, and Italy was the most recent to declare that essentially the parental alienation was a tactic of continuing abuse. But most courts now, at least the ones I've experienced in the US, start with the belief that the children are entitled to relationships with both parents, no matter what the history of abuse has been. So that even if claims of domestic violence are proved accurate, the courts will go on to say, but nonetheless, the father has a right to see the children, and the children have a right to see the father. So safety has not been a priority in the US courts, and the way that the cavalier way in which the Castle Rock police handled Jessica's case is a prime example of our systems not, for the most part, not addressing the root causes of violence, particularly gender violence. So once the students study the cases, the two cases involving Ms. Lanahan, we start thinking in a more expansive way about what the remedies are for our clients. And one thing that I appreciate what the students do is they eventually recognize the limitations of law in dealing with these issues, and certainly the limitations of law in terms of the state response to gender violence. So this has made them eager to become advocates on areas involving human rights, and advocates for change in U.S. law. So it's the clinic does work locally, which I love to see implementing the human rights law on a local basis. As Carrie mentioned, we started by bringing resolutions for cities and towns to adopt, declaring freedom from domestic violence a fundamental human right. And Carrie can credit Lee Goodmark and I all she wants, but actually this started at a conversation I had with Carrie at a Northeastern Law School conference about implementation. And so this was one of Carrie's brainstorms, and we immediately took it up. And, you know, one thing that's been helpful to the students is learning the politics of doing this. In Cincinnati, when we brought this resolution, it was close on the vote. We got lots of support initially, but then the more it went on, the closer we were to elections. And if it weren't for the chair of the city council who called in some favors, this resolution would not have passed. Whereas other communities, such as Boston, passed it without objection, and not only passed it, but stayed in contact with the clinic on how we could not just make this a resolution that has no impact, but how can we implement it? So clinicians from all over the country brought these resolutions, and it makes a difference for the students to see that this is an issue that they can get support from, although they may have to work very hard on it, which is a good experience for the students. The other pieces of the human rights at home work that I really like is that it gives our clinic flexibility on what we're working on human rights issues. So, for example, in addition to doing these resolutions, we have responded to community needs as they arise. One is that one of the first projects we took on locally was to study the transportation systems in our area. And we wrote a report from a human rights perspective on what does the system need, beside from the usual things of running on time, but just access for the disabled. How do people with vision disabilities see a bus, flag down a bus when in a rural area where there are no regular stops, but you literally have to flag down the bus when you see it coming. The students were able to view this from various perspectives. And the local transportation company was very responsive to us. I mean, they couldn't implement everything we recommended. Some of it was very high tech, but they were responsive and implemented changes in routes that we suggested to make life easier and other implementations. We also, representing survivors of domestic violence has been a constant for us, but we've also taken on working with an organization whose mission is prison abolition for women and girls. So that has been a wonderful experience for the students, both in doing research so that advocates can propose legislative changes, but also in lobbying and advocating for change within our state. So these issues have become human rights issues, and the good thing about it is that the students spot the issues, right? So students will come saying, well, you know, here's a serious problem that is a human rights issue. And so, for example, how transgender individuals and other members of the LGBT community are treated in our state. And so we offer to represent transgender individuals seeking name changes. That's been a successful project, as has been helping people seal their criminal records so they can obtain housing and work. But all of this stems really from Professor Bettinger-Lopez's work on shifting the framework on how we view the clinic work that we are doing. And I have not kept track of the time, so I'm not sure if I'm running over. But let me know if I am, Paula. So the other benefits to students has been that they see themselves as being effective advocates. particularly when you take something seemingly small, like the local resolutions to declare freedom from domestic violence a human right, it has a profound change and significance for the students to know that they can make that impact locally. And it prepares them to really dig into an issue, know exactly what the resistance is going to be, or go out in the community and learn what the resistance will be. So this makes them effective advocates, which they then carry over and combine with their courtroom advocacy to shift the perspective of the court beyond what historically has been the treatment of family law cases and the treatment of domestic violence, to the courts taking a different perspective on this. You know, this has various degrees of success, but one of our philosophy is that, you know, the courts have to hear this repeatedly from a significant number of advocates before they're going to really consider change. And so the students are part of that. And while they may not see immediate results, although some do in their cases, what they know is that they're part of a movement that is there to assist those who have experienced domestic violence. And when Spirits of Flagging, we talk about the Lanahan case and how that tragedy, through skillful lawyering, led to a shift in how we're focusing our perspectives of domestic violence. Another project I want to mention that is a good example of resistance is that there's a movement in the United States to raise the age of marriage to 18 with no exceptions. I believe 5 states have adopted it so far. My students have been working on this in Massachusetts for now, I believe we're going into our 3rd year. It's gaining a little more momentum. Our legislature, the House, one part of our legislature passed it. Another is more resistant for reasons that we don't entirely understand because we have buy-in from most communities. But it's been a great experience for the students to know that they can also have a part in changing legislative responses to violence. And we know that particularly girls who are married under the age of 18 are repeatedly subject to abuse and more likely to be raped or have been raped. So thank you, Professor Bettinger-Lopez, for leading me down this path. I'm very grateful, and I would encourage anyone who's thinking of beginning a human rights clinic to think about how these issues are local as well as national and international. And one other thing I'd like to encourage you to do is we do have a Human Rights at Home blog, which is open to law professors to write. And certainly we would love you to share your experiences with us through a post. It doesn't have to be very long, but I think it will be a great way to keep the community connected on what the clinics are doing. So thank you again for inviting me to speak, and I'm among great company, so thank you.
Thank you so much, Professor Drew, for sharing your experience and your knowledge with us. It was very insightful. I was hearing you and thinking at the same time, and compliment what Professor Lopez said. So I believe that the phrase that bringing human rights home and think about domestic violence and think about how to change not only the law but the culture. There is a real problem when you think about domestic violence. It's really important, and the work that you've been doing is amazing. So thank you so much for sharing. If you have the link of this blog to share with us, I don't have it. So
if I can figure out how to put it up, I will. Otherwise, I'll email it to you.
Okay, perfect. Thank you so much. And now I will switch to Professor Elizabeth Keys. We're going to change a little bit about the subject, still in human rights, but now we're going to talk about immigration. She is Associate Professor of Law, Immigrant Rights Clinic. She also works with clinical legal education, immigration and naturalization law. Professor Keys directs the Immigration Rights Clinic in Baltimore University of Baltimore. Her teaching, scholarship, and practice all focus on improving access to justice for immigrants in the immigration system and other intersecting areas of law, from criminal to family law. Thank you so much for being this panel, Professor Keys. A pleasure to hear you and hear your experience. The floor is yours.
Thank you, Professor Montero and Professor Baker, and to my fellow panelists. I'm really pleased to be here with you today. I am really bridging the last two speakers in a way because domestic violence is a reason many of the clients that my clinic represents are coming to the United States. They're coming here fleeing domestic violence and seeking asylum in the United States. It's also one of the only places where an international human right is actually explicitly included in our domestic law, through the Refugee Convention, which, unusual for the United States, we signed on to. So my clinic takes that issue and brings it down to the individual level. And I'm going to talk both really about what we do, but equally how we do it with the students. So largely in my clinic in Baltimore, we represent individual asylum seekers. Since 2014, that has been entirely Central American families. We respond to the needs in the community, and since the numbers started rising 7 years ago, that's been the overwhelming need. So the asylum itself, the definition will seem familiar to you, and I'm going to see if I can share my screen. It's not a big deal if I can't. No. The basic refugee definition is what we're trying to prove, and that's that people have a well-founded fear of persecution on account of one of 5 protected grounds: political opinion, religion, race, nationality, and membership in a particular social group. So that's the same definition everywhere. Brazil does get to benefit also from the Cartagena Declaration of 1984, which expands the definition a little bit more broadly in very useful ways. We don't have that. We're at the United States are not part of the Cartagena Declaration. But it provides inspiration. So the work of applying for asylum really happens in 3 different places geographically. There are law clinics that work a lot right at the border as people are initially seeking entry and being screened and oftentimes rejected right there at the border. And of course, many migrants are coming from as far as Brazil because Brazil is on the route to people coming from, say, Africa and other places up through the Americas to reach the United States. Inside the country, the action happens in one of 2 places, local asylum offices across the country. There's about 15 of them, where they get a chance in a less formal proceeding to make a claim. And they can bring a lawyer, and so sometimes our clinic students go to that interview. The bulk of our work, though, happens in immigration court. So most of these asylum cases, for any number of reasons, end up in immigration court. And it's like many courts that serve, among others, poor people, it's overfilled and under-resourced, and the level of protection and attention that any given case can receive in immigration court is really low. So a typical, well-argued, full hearing on asylum is 2 hours. And that's including interpretation, which of course slows things down. So we're debating somebody's life or death in the setting that some have likened to traffic court. Lots of people coming through, not a lot of attention. It's a very difficult place to practice. So that's where I want to sort of segue into how we do the work that we do, because essentially the work itself is not headline grabbing work. It's not impact litigation, it's individual clients. So how do we do that with law students? And especially, how do we do that when the law students, and I know there are students listening here today, so maybe this will feel familiar, they start every semester terrified that through a mistake of theirs, they will be responsible for somebody being deported. My job as the professor in the clinic is to make sure that does not happen. So a bit about my clinic. I'm one of about 10 clinics at the University of Baltimore, but the only one that focuses on migration issues. The other clinics have done remarkable human rights work in this local way, including the domestic violence clinic that Professor Lee Goodmark was at when she did the resolution that you've heard about. And our community development clinic actually uses the human right to water as a basis for its tremendous advocacy on Baltimore's problematic water structures. But in my clinic, interestingly, as an international clinic, I actually get to rely on domestic law. So we get clients from any number of places, including from organizations working at the border, who will call and say, we have a family that's moving to Baltimore, they need help. If they're calling from the border, we will take their case and figure out somehow how to expand our capacity. The students who take on these cases are in charge of the cases. Our model in the clinic is that the student is the attorney. We give them the knowledge and the skills and the power to make the lawyering decisions. And we do that, this is why they're terrified, we do that through a combination of seminar each week that teaches a good cross-section of skills, supervision meetings where a lot of the intensive casework happens, and then the client work itself. So these are second and third year students. Some have no experience at all. It may be their first client they've ever worked with. Others know quite a lot, but that's the exception. And we're teaching them everything: how to start a relationship with a client, how to work with an interpreter, because most of the students do not speak Spanish, which is the language most of our clients speak, how to counsel clients, how to determine the best legal arguments and prove that the clients actually meet those legal arguments. So the students are strategizing about all of these things and they're learning. And what we do basically is give them some of the baseline skills in seminar and through readings and whatnot, and then they can practice in seminar in small pieces some of what they need to do. And then we use in supervision their client work to really pull out what is going on in this case, what are the options, what assumptions are the students making about their clients or about the legal system? And how do we sort of pull back and get a better view of what they are, of what is happening? And we have a motto at University of Baltimore that we plan, we do, we reflect, and then we adapt. And so let me just give one example of how that might work. Students are about to meet, say, a family of asylum seekers. They need to first come up with their plan for that meeting, which means they need to know their goals. They need to think about the client's goals. They need to think about logistics, even like how to work with the interpreter, where people will sit, and of course, now how to make this all happen online. That's been interesting. So they come up with a plan, and then together we look at this, and I'll ask questions, and they'll start to realize, oh, I didn't think about these things. I'm assuming it will go like this, but what if it doesn't? So we do all the planning, which also allows us to raise ethical issues, and there's more learning. But then they go do the thing. So planning is first, then they do the thing, the interview. And that's actually, while that's important to moving the work forward, it's actually the third stage where all the learning really happens, which is our reflection, which is very intentional. What worked? What didn't? What surprised you? What did you learn? What will you do differently next time? What do you want to keep? Because the students have successes. And so we certainly want them to sort of appreciate what they did well, but then we adapt. So the next interview, might be in a different setting. It might be, dividing people up in different ways. I could go on. And that's just for a client interview. We're doing that with sort of every stage of the representation, from counseling to evidence gathering, brief writing, and of course, going to court. So the challenges of leading students through this work are pretty significant. It is very hard as a lawyer myself to give them the space they need to be able to make some mistakes without giving them so much space that those mistakes have real consequences for the clients. I often take cases of my own over the breaks, and it's a lot faster if I just do it. But if that were my model with the students, they just wouldn't learn as much. So that's sort of a interesting, challenge to navigate. The court system itself is really challenging to navigate. Some of the clients entered the country. We have cases this fall for, family that entered 3 years ago, which is actually really quick in immigration terms. We just finished for a family that entered 11 years ago. And so evidence goes stale, memories change. It's really hard. And again, in court, you're being rushed along because there's too many cases, too few judges. It's hard. Doing this work in the Trump administration, when the government was very purposefully trying to limit the relief available as well, was a layer of difficulty on top of it. One good thing and then one bad thing about the subject matter for a clinic is the students are engaged. When they feel that somebody or a whole family's future is in their hands, they work so hard. I never have to get my students to work harder. I might need to get them to work more strategically, but they want to do well. And so that's been really good. The other side of it, though, is that these cases are emotionally extremely difficult. And here that is no different than what Professor Bettinger-Lopez and Professor Drew have already discussed. These cases are hard, factually. and they can be hard emotionally on the students. So one thing over the years is that we actually teach mental health issues in the clinic explicitly, both to understand the effect trauma has on our clients, the effect trauma has on the representation, but also the effect it has on the lawyers. And that's been really good, but students don't come to law school to talk about their feelings. So sometimes I need to encourage them to see the role and make the connections. And Professor Drew mentioned the limitations of law, that the students are really grappling with the fact that sometimes the law is just not there. With our Central American cases, they're fleeing in large part gang violence or domestic violence. Domestic violence is coming along. It's a bumpy road, but those claims, there's a bit of a path. Gang violence claims are very, very difficult. And we can be creative, and we are, and win, but sometimes we don't. Because the way our asylum law without Cartagena is drafted, there needs to be a very tight connection between the harm and the reason that the gang is doing the harm. It's not about generalized violence. So those cases are hard. And when we lose them, we see the limitations of the law. So one thing we also teach, and I will actually wrap up on this point, is creative advocacy. Within their own cases, like what other options are there? What creative arguments could you make if you could reimagine the case law so that your client would have a stronger case? What is that? And then working backward, is there some way to get from where we are to where that is? Do we think this case might be good on appeal to change the law? Should we involve an appellate lawyer at this stage to make sure that we're preserving those arguments? And that's been really helpful to think beyond what the actual work of the students during the semester is. How could this flaw in the law change in the future? But also, how do we change the law? What is stopping advocates from having the resources in court they need, from having the laws they need, from passing immigration reform, which is this Herculean? It feels unreal to me that we could fix our immigration laws. But I will not give up my hope in that, because I want the students with their energy and their fresh perspective to know that it's their responsibility to go out and try to make things better. Everybody you're hearing on this call knows all about fighting for change. But what gives me the most hope is that these students come in seeing the system, experiencing how wrong it is, and with energy to go out and do something about it. And we, through our sort of teaching of the ethical norms and professional norms of law, we really emphasize that lawyers have a duty, it's written into our rules, we have a duty to improve the legal system. And so we try to take what's hard about these cases, the system itself, the law itself, and let that be an inspiration for the students to continue their advocacy once they're outside of my classroom. And as a clinical teacher, I have to say one of the rewards is that you see them in practice doing exactly that. So on that note, I will stop. But again, I'm grateful for the opportunity, and muito obrigada.
Thank you so much, Professor Kiss, for your inspiring words. And I'm here. I don't know if you see it, but I have some of other teachers from the other panel. They wanted to join us in this panel, and they are sending messages that say, "Oh, this is so inspiring. Always as a refreshment when we think about human rights." So I want to be an intern in every legal clinic that you presented here. I'm going to go to Professor Lopez, Professor Drew, and yours, and Professor Paula that's going to talk right now about Wisconsin. So thank you so much for your inspiring words. And I'll present Professor Paula Terrones. She's Immigrant Justice Clinic. She's a clinical instructor. She provides legal representation to individuals seeking immigration relief as a defense from removal or deportation proceedings, including asylum, special immigrant, juvenile status, and cancellation of removal before the Chicago Immigration Court and the U.S. Citizenship and Immigration Service. She also was a law student intern at Immigration Justice Clinic in Madison, Wisconsin. Professor Paula, the floor is yours. Thank you so much for being with us.
Yes, thank you. Thank you, Paula, for that beautiful introduction. And thank you, Elizabeth and Drew. You are so inspiring. The work that you do in your clinics is so important. And I was one of those students, actually, taking part of those cases that it's hard. It's hard dealing with a very complex and unjust system, but it's not impossible. And that's always our hope, that there's hope and something can be done. Something must be done. So it's a pleasure to be here. Thank you, Paula, for extending the invitation to the Immigrant Justice Clinic to this wonderful event. So I'm not going to take more time. I'm just going to go dive into the presentation that we have for all of you today. And so today I will be talking about children seeking refuge in the United States in detention. If you can go to the next slide, I'm just going to try to go as fast as I can because I have so much information. But this is the outline of today's presentation. I'm going to be focusing on Title 42 and the effects of the Trump administration. I'm going to talk about the process of unaccompanied migrant children at the southern border, the issues faced in terms of accessing legal representation, some of the protections offered in the United States for minors here. Specifically, I'm also going to talk about the emergency intake sites. This is something new, and also what can we do in the future. First of all, talking about Title 42, I just want to say right out the bat that it's a very complex regulation, and it has several parts to it. But in a nutshell, it's a health emergency regulation that was issued by the Department of Health and Human Services on March 20 of last year, preventing or prohibiting certain individuals from entering the United States during a health crisis. Actually, the Trump administration utilized and took advantage of Title 42 to prevent many people from seeking asylum in the U.S. during the COVID-19 pandemic. As a result, this regulation granted a border protection, it granted the U.S. Customs and Border Protection, what we call CBP, such as Border Patrol agents, the authority to implement this regulation at the border. So after this order was issued, Border Patrol agents began to expel migrants arriving at the border. They began sending most Mexican, Guatemalan, Honduran, Salvadorian families and single adults to Mexico. Those who weren't sent back to Mexico, are held at in U.S. Immigration and Customs Enforcement, what we call ICE, or we know as ICE, or CBP detention, and are flown back to their home countries without any opportunity to seek asylum in the U.S. So as a result, Title 42 has blocked over 750,000 people from seeking asylum as of October of 2020. In addition to turning away asylum seekers, CBP agents use this order to turn away and expel unaccompanied minors. However, thanks to a federal judge who held that the expulsion of unaccompanied minors violated the Trafficking Victims Protection Act, On November 18 of last year, 2020, the federal government under the new Biden administration provided an exception, and that exception applied to unaccompanied minors. As a result, this has effectively encouraged some desperate parents to send on their own their children to the United States in hopes that they will receive asylum while their parents are stuck back in Mexico. So under the Biden administration, the Biden administration has made efforts to end Title 42 and provide further exceptions to migrant families, not only unaccompanied minors, but to families, while continuing to freeze on other adult migrants. However, because as we know, there has been a rise in COVID-related cases, they have been rethinking this plan. As of right now, over 20,000 people are in detention, unfortunately, and the majority has tested positive for COVID. But the government is still refusing to release people for the most part. So I know that I've mentioned a lot of times unaccompanied minors, and that's a legal term if and of itself. So if you want to remain in that slide, Paula, I would greatly appreciate it. So what does it mean on the previous slides? If you want to go back, thank you so much. And yes, that one, thank you. So what is an unaccompanied children? What does it mean? So we have a definition under our immigration regulations, and it's minors who have arrived in the U.S. or are at the border without a parent or legal guardian. Actually, the term stands for unaccompanied alien children, but that's an ugly term and we don't use it. And therefore we use unaccompanied minors. And these children are under the age of 18. And as I stated before, who have arrived in the US already or are at the border without a parent or legal guardian. So some statistics that I wanted to share with you and some facts about this population of unaccompanied minors is that this spring, the U.S. saw a spike in unaccompanied children apprehended at the border, with nearly 18,900 children in March of 2021 alone. The majority of unaccompanied children tend to be teenage boys between the ages of 13 all the way to 17 years of age. Roughly about 2/3 of unaccompanied children are coming from what we call the Northern Triangle region that includes Guatemala, Honduras, and El Salvador. Children and their parents may choose this dangerous path of immigration due to, like the other professors mentioned, due to violent crimes, gang violence, domestic abuse, severe economic insecurity, persecution, abuse in their home country. Some are looking for greater economic opportunity or even better education opportunities, or even be reunited with family members that are already living in the US. So in my next slide, I've included a map, and this map is showing some of the detention facilities that are currently in place throughout the United States. These facilities include detention facilities, shelters, and foster homes in the U.S. The majority, if you're able to see, are near coast and borders and are run by a wide variety of organizations, including the government, the federal government, religious organizations, nonprofits, and private contractors. So you might be asking, wow, then what are some of the protections that are offered to unaccompanied children in the U.S.? There are many special protections that are coming from the 1997 Flores Settlement Agreement that I've included in my next slide. This settlement agreement arose in 1987 because of a class action lawsuit called Flores v. Reno. Among other things, this lawsuit or the ruling in this lawsuit provided that children must not be held with any adults who are not related to them. There must be release from detention without unnecessary delay to their parents or approved sponsors. And also, facilities for children must provide clean and temperature controlled conditions, water, food, medical care, ventilation, the correct supervision and contact also, and the opportunity, to contact their family members. So in 2015, a federal court ordered that migrant children cannot be detained for more than 20 days, although this unfortunately has not been followed in practice. The following year, in 2016, a federal court ruled that the Florida Settlement Agreement applied to both unaccompanied children and children with their parents. So in other words, any parent detained with the children, they couldn't be detained for more than 20 days. So what are the protections in the US? This slide, the one that is appearing right now, provides a list of immigration relief that is offered or that are offered to unaccompanied minors under our current immigration laws today. I would like to note, though, that children have a special legal, children that have these types of protections, they do experience very separate removal and asylum processes. So their cases don't look the same. And then some of the reliefs offered to unaccompanied minors are asylum, as we see in the PowerPoint, T visas, which is minors that have been victims of human trafficking, or they can also qualify for special immigrant juvenile status if they were abused, abandoned, or neglected by their parents. This specific juvenile status applies to unaccompanied minors if they are under the age of 21 and they are unmarried, and if it's not in their best interest to return to their home country. The children must go through a required guardianship process before petitioning this visa in front of U.S. Citizenship and Immigration Services before they turn 18. So they first go through a state guardianship process, and then after they can qualify to petition the special immigrant juvenile status. Therefore, it's imperative and it's very important that 17-year-old children that are in detention need to be released as soon as possible in order to get an attorney and be able to have even the opportunity to apply to this form of relief. So these forms of relief all provide a pathway to citizenship, and many even allow them to include what we call derivatives or beneficiaries, which is mostly their family members. So in my next slide, I would like to talk about then what's happening on the ground. So right now, under the Biden administration, they have created what they call emergency intake sites to deal with the search of unaccompanied children at the border. This type of sites, emergency intake sites, are under the administration of unlicensed administrators. So they are meant to act as better alternatives to overcrowded CBP custody detentions, but many have had extremely bad conditions with little supervision. The emergency intake site right now, it's only in Fort Bliss in El Paso, Texas. There were more in other parts of the U.S., such as California, in San Diego, San Antonio, and Houston, also in Texas. But right now, Fort Bliss has over 4,500 children as of May of this year, and was one of the most widely reported for abuse and negligence. So hundreds of children have been kept in these sites for upwards up to 2 months. But most sites are closing, as I stated previously, or have already been closed, as fewer unaccompanied minors have arrived. Actually, with the Immigrant Justice Clinic, we volunteer at this emergency intake site. So we saw firsthand some of the issues and troubles faced by unaccompanied minors here. So now I would love to talk about more of like the detention process. Okay, you might be asking, so what does an unaccompanied minor have to go through since step one? So under the Wilberforce, it's a long name, Trafficking Victims Protection Act of 2003, border agents are supposed to screen children for evidence of trafficking or persecution more thoroughly than they did in the past. So when unaccompanied children are apprehended by Custom and Border Protection agents, CBP officers, or ICE officers, they are briefly screened by agents to determine their country of origin. For those countries known as contiguous countries, which are those that are sharing a border with the U.S., such as Mexico and Canada, of course, and Canada, unaccompanied children for those countries go through a very unique and different apprehension process. Customs and Border Patrol agents simply give them a brief screening, such as, are you a victim of trafficking? Maybe they're seeing if they have a possible asylum claim by asking, are you afraid to go back to your home country? If the children do not meet this criteria by the officers, they are supposed to be returned to a child welfare officer in their home country, meaning in Mexico and Canada, without suffering any penalties. Critics of this policy point out that this is very confusing and has no clear reasoning for the legal difference that they're making between this children coming from these contiguous countries versus the children that are coming from the Northern Triangle. Because on the other hand, if you want to remain there, on the other hand, children that are coming from the Northern Triangle, countries that are not Mexico and Canada, which is like El Salvador, Guatemala, Honduras, they go through a more rigorous process. Within 72 hours, of apprehension, they must be transferred to the Office of Refugee Resettlement, what we know as ORR, in the Department of Health and Human Services. So ORR shelters are staffed with trained child care providers who screen children to determine if they are victims of human trafficking or if they have a credible fear of persecution. So when a suitable sponsor is found, such as like a family member or a very close friend of the family living in the U.S., HHS, which is the Department of Health and Human Services, release the children into the custody of the specific person and for them to go through the removal process in court. So on average, children coming from the Northern Triangle spent about 27 days in ORR facilities before they are released to suitable sponsors, if a sponsor can be identified. Otherwise, this amount of days only increases. The average wait time for a hearing in immigration court is about 2.5 years, with a current backlog of cases. So it's a very long and arduous process, very difficult. They go through a lot. It's not easy. And here I want to show some pictures of the reality that these children face. Children often face much longer times of detention, even though I had mentioned to you that they're approximately spending about 27 days in the in ORR facilities. They spend more time in detention because, as you see, before they even placed in the custody of ORR, they go through another process where they have to go through a perrera or hielera. So you see photos. The first photo was from 2018, which shows children in what critics have said or called perreras. This photo showing right now is actually recent, from this year, March of 2021, showing children in plastic enclosures, sleeping on mats on the floor without space for social distancing. Many facilities have had overwhelming spikes of COVID, and over 20,000 immigrants have tested positive for COVID in ICE detention facilities alone. So this is a very big and horrific issue that right now we're dealing with, and that unaccompanied minors are facing. So that is why it's very important that we advocate on behalf of unaccompanied minors, that we support organizations providing resources such as legal representation to unaccompanied minors. And the statistics shown here is, it's going to be, I will be talking about like the legal representation and the difference between unaccompanied minors that are able to secure legal representation and those that unfortunately do not. So aside from facing dangerous detention conditions, unaccompanied children face many challenges. Among many others, they face the fact that they have no right to a court-appointed attorney. The expense and burden of getting an attorney falls on the child 100%. Unless they can afford an attorney or secure pro bono counsel, they appear in court without legal representation and are expected to represent themselves against trained government attorneys. There is no guarantee to counsel. Children are at the center of a larger due process crisis in immigration courts that fail to provide counsel to the most vulnerable individuals, despite the serious risk of violence or trafficking upon deportation from the U.S. Without a lawyer to help their immigration court proceedings, only 15%, and that was my statistics on the previous slide. So without an attorney, only 50% of unaccompanied minors remain in the U.S. In comparison, with legal representation, 88% of unaccompanied minors are able to win their cases and remain in the U.S. Wow, that's a big difference, right? So once a child is released from ORR, from the custody of ORR, and they are released to a sponsor, it's the child's responsibility, regardless of their age and regardless of whether or not they obtain an attorney, to submit legal documentation, legal paperwork to inform the court that the child has moved states by filing a formal, what we call motion to change venue. So children who do not properly update their address or don't file this motion to change venue, and they do not appear in court, they are ordered deported for failing to appear. So it's a big consequence that they're facing if they don't have the help, the guidance, the resources, or to get an attorney or to have somebody help understand what the process even looks like, what they should be doing, what type of documents should they be submitted to court if they move. If they don't even have to move states, even if they move just addresses within their city. So it's a very complicated process. There has recently been some progress to fund more lawyers for children, but many children still are facing judges alone. So what is there that we can do? What can we do as individuals or members of society to have a positive impact in this huge issue? So I provided a list. Attorneys, I would encourage more attorneys to try to represent more children, unaccompanied children, through the removal process. We must fight or continue to fight because this has been a long way in fighting to end child detention. We must also end this alternative to detention, such as the emergency intake sites, because they operate as detention facilities. And we must obtain more resources to help with the push factors that are pushing these unaccompanied minors to migrate to the United States, such as climate change. So I don't want to leave this presentation without speaking a little bit of the effects of the Trump administration and the changes that have been evolving under this new administration. During the Trump administration, there were over 400 changes in immigration law. It seemed like every day there were more than 2 changes in immigration law, without a single law ever being passed through the legislative process. Among other changes, it eliminated domestic violence and gang violence as grounds for asylum, leaving many children and families and women in general in dangerous conditions. Trump's migrant protection protocol, what we know as Remain in Mexico, the Remain in Mexico policy, forced migrants, including children, to stay in Mexico while waiting for the chance or the opportunity to apply or receive asylum. Many families lived on the streets in Mexico for years without a guarantee of ever reaching the United States. The Biden administration has ended its protocols and is prioritizing processing those people who have been waiting for a long time. Trump's family also implemented a separation, or what we know as zero tolerance policy, who separated a lot of families of about 3,900 children from their parents. But the administration did not keep clear records, so we're not very sure, of the exact number of families that were separated or children that were separated from their parents. The Biden administration has prioritized locating the families of hundreds of children who still remain separated. So this is a rising issue of unaccompanied minors coming here to the United States. And they are facing a very, very big issue, not being able to access legal representation, which is very vital in their immigration process. Besides their age, like I stated before, they are facing so many issues that children shouldn't go through, or even not even any human being should go through. So I want to end my presentation by saying that there is still a lot to be done. Aside from pushing our Congress representatives, it's important, as I stated before, to support our local organizations that are currently helping this issue and spreading our voices, right, in support of better immigration policy. So I know I rushed through my presentation a little bit. There's a lot of information. And therefore, in the Immigrant Justice Clinic here in Madison, Wisconsin, which is part of the University of Wisconsin Law School, we have made it a priority to help unaccompanied minors to help this issue. We are planning more trips to the border in order to know how it works on the ground, and what are the things that they need, unaccompanied minors need, before even being released from detention, in order to better serve them once they are out of detention. We want to be able to equip them with as much information as possible and the resources such as the form that they have to submit once they are released and change address. So there's many things that we can be, that we want to continue doing. So thank you, Paula, for allowing me to present on this issue. And thank you, everybody, for taking the time to listen.
Thank you so much, Professor Perla, for sharing this information with us. It was really touching to see the photos. I speak for myself, but I believe everybody was touched with the kind of photos. And this is a major human rights issue that draw our attention. And I thank you for Wisconsin to taking the time and the efforts to deal with this specific part of immigration. And thank you for sharing this material with us. Without further ado, I know that we passed a little bit of our time. It's fine. I was happy to hear you all. I would invite Professor Jeff to turn on his camera right now. Professor Jeff, can you hear us?
Yes, right now.
Thank you so much. This is our last panel of our International Conference on Access to Justice and Legal Clinics. And I was very happy to see a panel just with women. It was important for me, and it's important for us as empowerment. And Jeffy it's an amazing partner, and it's always fantastic. And he was always there when I planned in my head, and then I talked to Jeff with this idea. And as I did with him with so many projects he did with me, he said, okay, let's do it. And then this the kind of partnership that we need when we talk about human rights and legal clinics. And we hear you all with your projects and practical work. It was really inspiring to hear women talking about the human rights and their efforts and the work with legal clinics. And I'm very emotional. That's why it's so hard, because being emotional in our language is already hard. Being emotional in English is even harder. But I would like to thank you so much, to thank in the name of Ibmec, that is my university, Ibmec São Paulo, on behalf of my coordinator, Icaro Leite. We'd like to thank you all for your work, for being here, and on behalf of Mackenzie and the University of Rosario. They are not here presently, but was part of the organization. I'm not talking about Pepperdine because I will pass to Jeff, so we can end this amazing 3 days, and hopefully we'll have this again. Jeff?
Yes. In perfect clinic style, Paula and I had this conversation about having a conference at the end of the summer, really at the beginning of the summer, and or summer for us, winter for you, and to be able to see it come to pass is wonderful, and I'm grateful to see my great friends on this panel. One of the things that I love about our community of clinicians in the U.S. and now our community of clinicians as it grows is that we work together and build each other up, and we typically don't have rivalries with each other. We are interested in collaboration and growing. Margaret on this panel is integral in bringing me into the clinical community when I was a new young clinician, now 15 years ago. And I was mindful today that on Carrie Bettinger-Lopez's slides, she had a map of the United States with pins in certain places around the country where we had brought forth human rights resolutions to declare that domestic violence is a violation of human rights. One of those pins was in Montgomery, Alabama, which was the fruit of our work at the Family Violence Clinic in Alabama, which was heavily under the influence of Margaret Drew and Lee Goodmark, who were helping follow the lead of Carrie Bettinger-Lopez. And now today we're all together speaking with you and our friends in Brazil and around the world. So I love this community, and I'm grateful for you all and for your heroic and thoughtful, really creative work and teaching. Thank you to my friends in the U.S. for joining us today. I want to meet Perla Rubio Terrones soon in real life, and just so grateful. So thank you, Paula, for taking the lead and for organizing this. Thank you to Ibmec, to Mackenzie in Sao Paulo, and I'm grateful for the support of Pepperdine Caruso School of Law here as well. And just grateful for everyone. This is our last note. Thank you all for hanging on a little late. We are grateful for this week and our exchanges that we've had together. And you inspire me at the beginning of our school year to do more good work with our students as we go. So that's my final word. Blessings on everyone, and thank you very much for your work today and for your work this week. And Paula, as always, it is a pleasure and gift to work with you.
Thanks so much. Likewise, Jeff. Thank you so much for all of you for being so inspiring. I hope to see you soon and talk to you soon. I will end this in Portuguese as I must. So, muito obrigada a quem nos acompanhou, a todos e todas que estiveram conosco aqui na Conferência Internacional sobre Acesso à Justiça e Clínicas Jurídicas. A gente se encontrará em breve. Em nome do Ibmec São Paulo, eu encerro o nosso último painel. Muito obrigada. Thank you so much, everybody. Talk to you soon. Bye-bye.
Thank you. Bye.